stop whatever you are doing right now. If you have a work permit, an employment authorization document, or if someone in your family does, the next 4 minutes of this video could be the most important 4 minutes of your week. Starting this week, USCIS has implemented rule changes that directly affect how work permits are issued, how long they are valid, and whether automatic extensions you may be counting on will even apply to your case anymore. I want to be precise with you because this is not a rumor. This is not speculation. These are documented regulatory and policy shifts coming from the Department of Homeland Security and USCIS itself. And if you are not aware of them, you could find yourself in a situation where your work authorization lapses without warning. There are 4 specific changes we are going to break down today, and by the end of this video, you will have a clear, step-by-step action plan so you know exactly what to do next. Stay with me. My name is Raymond Crivello. I am a senior immigration analyst and consultant, and on this channel, I break down complex immigration developments into clear, fact-based analysis you can actually understand. We do not do panic here. We do not do rumor. We do policy, with precision. Before we go any further, I need to give you an important disclaimer. I am not your attorney, and this content is for educational and informational purposes only. Immigration law is deeply fact-specific. Please always consult with a licensed immigration attorney about your particular situation. Now, let's get into it. 4 USCIS changes. What they are, who they affect, and what you need to do about it. Let's start with the single most significant change because this one is going to catch a lot of people off guard. For years, and many of you have relied on this, USCIS maintained what was known as the 540-day automatic extension policy for employment authorization documents. Here is how that worked. If you filed your EAD renewal on time before your current card expired, USCIS would automatically extend your work authorization for up to 540 days while your renewal application was pending. That is roughly 18 months of continued authorization without needing a new card in hand. It was a critical protection. Because USCIS processing times can be painfully slow, this rule ensured that people did not fall out of work authorization simply because the agency was backed up. But here is where this becomes critical. For applications filed after October 30th, 2025, and this is now fully in effect in 2026, the automatic 540-day extension no longer applies universally. USCIS has rolled back this protection, and the automatic extension has been significantly curtailed for many applicants. New applicants in affected categories will not receive that same automatic bridge they may have counted on in the past. What does this mean practically? It means the clock is real. If your EAD is expiring and you do not have your renewal in hand, you may face a gap in work authorization. And a gap in work authorization can have serious consequences for your employment, for your employer, and potentially for your overall immigration status. The authority behind this change comes from DHS's regulatory power under the Immigration and Nationality Act to establish conditions on work authorization. This was not a congressional act. This was an administrative regulatory change, which means it can move quickly, and it did. The second change directly follows from the first, and for asylum seekers and refugees in particular, this one stings. Previously, USCIS had been issuing EAD cards to asylum seekers and certain refugees with validity periods of up to 5 years. 5 years gave families stability, it gave employers confidence in hiring, it reduced the administrative burden of constant renewals. Under the new policy, USCIS has reduced the EAD validity period to just 18 months for newly issued cards in these categories. This is what many asylum applicants are misunderstanding right now. USCIS has framed this reduction as a national security and vetting enhancement measure. The stated rationale is that shorter validity periods allow for more frequent review and revetting of individuals in these categories. From an administrative law perspective, DHS is invoking its authority under 8 CFR Part 274A to set conditions and duration of work authorization. But here's the practical reality for applicants. If you are in asylum-based work authorization and you just received or are about to receive a new EAD, you should expect it to expire in 18 months, not 5 years. That means you will be back in the renewal queue faster. And given what we just discussed, the reduced automatic extension protections, that renewal process becomes significantly more urgent. Plan accordingly. Begin your renewal process early. The standard guidance used to be 180 days before expiration. Given current processing delays, I would strongly encourage you to consult with an immigration attorney about starting that process even earlier. Let me make this real for you with a hypothetical scenario that represents what thousands of families are facing right now. Meet Farhan. He is a 34-year-old software developer from Pakistan. He came to the United States 4 years ago, filed for asylum, and was granted work authorization under the C8 category. His employer, a mid-sized tech company, has sponsored his continued employment based on his valid EAD. Farhan's EAD expires in July 2026. Under the old rules, he would have had that 540-day automatic extension cushion from the moment he filed his renewal. He would have felt secure filing around January or February. Under the new rules, that cushion is gone or severely diminished, and his newly renewed card, when he does receive it, may only be valid for 18 months, which means he is immediately back on the renewal treadmill. His employer's HR department is already nervous. They need documentation, they need assurance, and Farhan is caught between a bureaucratic system moving slower than it ever has, and a policy environment moving faster than most people can track. This is not abstract. This is happening, and the reason I want you to hear Farhan's story is because whether you are Farhan, whether you are Farhan's spouse, whether you are Farhan's employer, this policy shift affects you directly. There is one detail most people are completely missing about what is being proposed right now. As of late February and early March 2026, DHS and USCIS have floated a proposal that, if implemented, would be among the most operationally significant asylum work permit changes in recent memory. Under this proposal, if USCIS's processing backlog for asylum-based work permits, the C8 category, exceeds 180 days, USCIS would have the authority to stop accepting new applications in that category entirely until the backlog is reduced. Let that sink in for a moment. If this rule is finalized, it would mean that a backlogged agency, which USCIS already is, could effectively close the door on new work permit filings for asylum seekers during precisely the periods when applicants need access most. Now, this is still a proposal as of early March 2026. It has not been finalized, but proposals from this administration have moved to implementation quickly. If you are in the C8 category or are about to file in that category, this is something you need to be discussing with your immigration attorney immediately. Not next month, not next week. Now. From a legal process standpoint, this type of rule would typically require a notice and comment period under the Administrative Procedure Act. However, the administration has signaled it may pursue interim final rule options that allow for faster implementation with reduced public comment timelines. That is a significant procedural point that immigration advocates are already challenging. Court challenges are likely, but do not wait for the courts. Plan as if this rule could take effect. The fourth change is more straightforward, but it directly affects your wallet and your planning timeline. Effective March 1, 2026, USCIS has increased premium processing fees across multiple petition categories. These increases are tied to an inflation adjustment mechanism that USCIS is permitted to apply under the Consolidated Appropriations Act. If you were planning to use premium processing to expedite an EAD renewal, an H-1B amendment, or another petition type, the cost is now higher than what you may have budgeted. I would strongly recommend visiting uscis.gov directly. The fee schedule is updated there, and confirming the current fee before submitting any payment. This could affect you even if you are not filing right now. If you are an employer funding immigration filings for your workers, update your legal budget projections. If you are self-funding, make sure your financial planning accounts for the new fee schedule. Incorrect fees submitted with a petition will result in rejection, not just a delay. Rejection. All right, you have the information. Now let's talk about what you actually do with it. Step 1. Know your EAD expiration date. Right now, today, pull out your card, check that date, and write it somewhere visible. If it expires within the next 12 months, you need to be in active planning mode immediately, not eventually, now. Step 2. Consult a qualified immigration attorney. I know that sounds like a standard disclaimer, but in this environment, it is genuine, urgent advice. The rules are changing faster than most people can track. An attorney who is monitoring USCIS policy in real time can give you case-specific guidance that no YouTube video can provide. Step 3. File early. Given reduced automatic extensions and increasing backlogs, filing at the absolute last moment is no longer a viable strategy. Work with your attorney to establish the earliest possible filing window. Step 4. Stay alert to the 180-day backlog rule development. Monitor USCIS.gov and the Federal Register for any notice of proposed rulemaking or interim final rules affecting C8 applications. This is a live situation and it can change rapidly. Step 5. Watch out for scams. Anytime there is a policy shift this significant, bad actors emerge promising fast approvals, guaranteed results, or guaranteed extensions. If anyone is making those promises, walk away. USCIS does not offer expedited processing through unofficial channels. Notarios are not attorneys. Protect yourself. Let's step back for a moment and look at the bigger picture, because understanding the context helps you plan with greater confidence. The changes we have discussed today reflect a broader administrative posture that prioritizes increased vetting, shorter authorization windows, and reduced automatic protections for applicants in the pending queue. This is not a temporary glitch. This appears to be a sustained policy direction from DHS and USCIS under the current administration. What can change these policies? Congressional action could mandate minimum EAD validity periods or restore automatic extension protections through legislation, but that requires both chambers of Congress and a presidential signature. Federal court challenges to the 180-day backlog rule, if finalized, are very likely. Courts have historically been willing to review USCIS procedural rules that affect large numbers of applicants without adequate notice. However, court challenges take time, months, sometimes years. You cannot plan your work authorization around an uncertain court outcome. What I want you to take away from this broader context is, the rules can change back, but do not count on it happening on your timeline. Plan for the environment as it exists today, while remaining informed about developments as they occur. Before I close, I want to be direct with you about why this matters so much. Immigration status is not just a legal technicality. It is the foundation on which entire lives are built. Your ability to work, your employer's ability to retain you, your family's financial stability, your children's sense of security, your long-term path to permanent residency, your eventual path to citizenship, if that is your goal. All of it depends on maintaining valid, documented, protected immigration status. A lapse in work authorization, even a brief one, can trigger consequences that ripple through every one of those areas. You deserve to have clear, accurate information so you can protect what you have built. That is exactly what this channel exists to provide. If you want accurate, fast, and reliable immigration updates, subscribe to Raymond Crivello right now and turn on notifications. Immigration policy is changing rapidly, and staying informed is no longer optional, it's essential. Drop a comment below and let me know what visa category you are currently in, whether that is Asylum, H-1B, family-based, or something else. I read every comment and your questions shape future videos. If you know someone who is on a work permit or is going through the immigration process right now, share this video with them. Seriously. One share could protect someone's livelihood. And if this video gave you clarity that you were looking for, give it a like. It helps factual immigration coverage reach the people who need it most. I'm Raymond Crivello. Stay informed, stay protected.